Hi, I'm John Strohmeyer with Strohmeyer Law, and today we're answering, who is in control? Well, this can be a pretty vague question, so let's figure out who we're talking about first. We've got three options in estate planning for who could be in control of your property. One, we've got you, the person who's doing all the planning. Two, we've got your agent under a durable power of attorney. Three, we've got a trustee under a trust you may set up. And four, we've got a guardian of your estate. With these four parties, who can be in control? Well, let's start at the beginning. Unless something else changes, you, as the person setting up any of your planning, will be in control of your stuff. You're the one who's in charge, and you'll be able to direct what happens and what shouldn't happen with your property. If one of the other people is working for you on behalf of you with respect to some of your properties, you can take back their power to act on your behalf and do what you can to undermine and unwind what they've done. So we're going to move, starting with that starting point of you're always in control of your property. Well, the first thing you can do is set up an agency relationship where an agent under a power of attorney can take actions on your behalf. That agent always works for you and will have to do what you say as long as you have empowered them. You can take away their authority to act on your behalf by just telling them, hey, you're no longer my agent, or you can do something more drastic by tearing up the agency document, that durable power of attorney document that you may have set up. If you have a power of attorney that is not durable, well, that durable portion means that if you're incapacitated, then the power of attorney is no longer valid. So in estate planning, we're typically setting up durable powers of attorney to make sure that the agents can still act on behalf of the principal, the person who set up that relationship, after the incapacity has occurred. This allows that person to take actions for them and ensure that things can still happen even though they're incapacitated. Now, the agent can only act as long as the principal is alive, so that relationship will terminate the moment the person dies. So power of attorney is good for ultimately or potentially for the rest of your life, but the moment you pass, any powers of attorney that you have created will no longer be valid. Option two is going to be if you have a trustee. So if you've set up a revocable management trust, that trustee can act on your behalf. If there are, but they can only act with respect to property that is in the trust. If they don't have the property in the trust, then they can't do anything about it. So there could be a potential conflict between an agent under a durable power of attorney and a trustee. The agent can control assets that are held in the principal's name alone, and the trustee can only control property that's held in the trust. So there may be a bank account, for example, that's still in the principal's name that hasn't been funded into the trust. The trustee would not be able to do anything with that bank account, but the agent could. Now, we could have an agency document or power of attorney that says, agent, if I'm incapacitated, make sure you fund all my assets into this trust, or you're directed to do this. If the agent then refused to do that or wasn't complying, we could get a fight. But otherwise, the agent's going to be in charge of assets that are in the name of the principal, and the trustee is going to be in charge of and can make decisions about assets that are funded into the trust. Lastly, we're going to look at a third option for a person is the guardian of their estate. Now, a guardian of an estate is somebody who's been appointed by a probate court to be in charge of what is known as the ward. So the ward is the person who's had the guardianship set up. The guardian of the estate is responsible for managing the ward's property. So the guardian is to take charge of all of the ward's assets and then manages them on behalf of the ward and also has to report back to the court. Now, the benefit of this is somebody is taking charge of things and can manage the assets for the benefit of the ward. The problem is this can be an expensive process, and once it gets set up, that agent or the guardian of the estate still has to report to the court every year until either the guardianship is terminated because the ward regains capacity or the ward passes on. And part of that is going to be reporting to the court what assets have been spent on behalf of the ward, where things have gone, what has been done. Now, if a ward before losing capacity had set up a trust, they may have created a trust where their assets are being managed for them, in which case the guardian of the estate would not be responsible for any assets in the trust. Instead, the trustee would still retain control over those assets. So what we want to think about is there are 4 parties that we're thinking about in determining who controls any asset. We're going to have the person who owns it. They can at first set up an agent under a power of attorney to manage assets for them. They could also set up a trust and fund assets into that trust, so the trustee manages assets for them. And finally, if they lose capacity, a guardian of an estate may be appointed to manage assets on their behalf. Any of these options are open, and each person will want to think about which one makes the most sense. Though one of the things we want to avoid is going to be avoiding that guardian of the estate.